All right, thank you very much, Andrew. Um, so we want to talk today about this new report that we recently issued on, our almost a decade, I think, long effort on workload studies. We're going to talk first about the history of the development of the Delphi methodology as we have done it, okay? We started in Missouri, and a great lawyer, Doug Copeland, who was former Lawyer of the Year and was then the chair of the Missouri Public Defense Board, said something I'll never forget. Doug had never been in a criminal court. It is a private practice, small practice, but he was asked to be chair of the commission. He did. He went into those courtrooms and he saw what was going on, and he said, "We have trained a whole generation of lawyers how not to practice law." Okay. There were three real heroes in this story, and all these people had done all of this work before I ever got there. Okay. Greg Mermelson is a brilliant lawyer. He's a general counsel. Cat Kelly had enormous courage to lead this, because this was really taking on the state and taking them on in ways that were very disturbing to the state. And they would pay a serious price for it. And Peter Sterling was what I call her enforcer, okay? Turn in your time and pick up your paycheck, okay? They have a statewide system, 350 some lawyers, and they actually got them to do reliable timekeeping, which has been almost impossible to replicate. They did, and they had the courage to start. They just started with the NAC standards, but you got to start somewhere, and they started. Okay. I came in and helped them in the Missouri Supreme Court, and a great judge who's recently retired, Judge Laura Deaver Smith, wrote for the court in State versus Waters. Some very important things. Effective, not just pro forma representation is required by the Missouri and federal constitutions. Judges cannot order public defenders to take more cases than they can handle competently. And she didn't cite this case, but it's good law in Missouri, Massachusetts, and in Florida. But there is a 1981 case which clearly holds if the state cannot provide a reasonably competent lawyer, the remedy is dismiss that case and release the defendant if the defendant is in custody. This is a very powerful remedy, okay? In some senses, maybe too powerful. Now, here's a great guy, okay? My companion, and he did some equally courageous things, okay? In securing reasonable caseloads and in his summary of it, with his recommendations, he had the courage to stand up and say, do not rely on the 1973 NAC standards. Because the Missouri auditor had looked at those standards right after we won, and he called me in, he said, Steve, there is no there, okay? And you can't, if you want to have the remedy of withdrawing, you can't have that unless you've got reliable data and analytics, okay? The other thing that Norm said was you ought to consider using the Delphi method, okay? So we did, okay? The Delphi method was developed by the RAND Corporation in the 60s and 70s. The RAND Corporation, you probably know, is a defense contractor. So this is not a liberal group. They have great credibility on this issue. And it was developed in order to produce a reliable consensus of professional judgment and opinion about matters that there might be different views on. And the Delphi method has been peer-reviewed and validated in the research literature. It involves both qualitative and quantitative analysis. This is empirical research, and it was frequently employed in needs analysis, which is exactly what we're talking here, needs analysis studies. So I did my own extensive literature review of the Delphi method, but I am not a researcher, okay? I'm a lawyer, and I knew that I needed help. So I did a search. national search for an accounting and consulting firm. And then 3 big firms turned me down because I only had 70 grand from the ABA. And I told Jim Castellano, what a great, courageous man this guy is. I told him, Jim, I've only got 70 grand. This is going to cost you 200, 300 minimum. But it's important. And after 20 minutes, he cut me off and he said, Steve, we're going to do this. This is really important. And I said, you know, I only got 200 or 300. I mean, I've only got 70 grand. This is important. We're going to do it. Really big moment, I think, for indigent defense. I had 3 tasks for Reuben Brown. Okay. Complete the literature review that I had done, produce the Missouri report, a workload study for the Missouri Public Defender, and produce a national blueprint. Okay. They did that. Okay. Here are the 8 distinguishing features of an ABA public defense workload study. Okay. As we came out of the Missouri project. Number 1, the professionals conducting the workload study must be facilitators, not arbiters of what is appropriate. Number 2, the facilitators must let the chips fall where they may. Okay, the professional judgment of the Delphi panel is what produces the ultimate results and the ultimate numbers in this thing, not those of us who are not public defenders and private practitioners. Number 3, the professional judgments of the public and private criminal defense practitioners on the Delphi panel alone provide the study results. We use private practitioners and public practitioners because private practitioners don't have the resource constraints, the serious resource constraints that public practitioners do. They have the constraint of the market, okay? And so they must limit their caseloads or they're going out of business. Get those 2 people and kinds of people in the room, get them to talk to one another. They probably have different views and get them to get to consensus, okay? That's historically a way that, an important way that the Delphi method has been used. Get people in the room who probably have different ideas and have the same or similar experience and see if you can get them to consensus. There are 2 skill sets in this kind of endeavor. One is the surveying and data analysis. And Malia's going to talk to you a lot about that because she's made major improvements to this thing as we've gone along. And I'm going to talk to you mostly about the law and standards. So there are 2 kinds of people we have to have here. Okay, we got to get some people in the room who know some things that we don't know about reliable data and analytics. Okay, the legal practice and ethical standards, not the results of any timekeeping data. Even though we had reliable timekeeping data in Missouri, are the appropriate anchors for the professional judgment in the study, okay? That's what's going to drive the decision. Now, we'll talk to you a little bit more on that. Number 6, to avoid institutionalizing current practices, timekeeping should never be used as an anchor for the professional judgment of the Delphi panel. Number 7, both a time required, how much time does it require, assuming you did it in every case, and a frequency analysis are required. Well, then what percentage of the cases would you do that? Who came up with that? Not Reuben Brown, not Steve Hanlon. The lawyers in the Delphi panel said, we will not answer time required without also being given the opportunity to say, how often will you do it? You could argue that might be double counting. That's what they said that we needed. That's what they got. Who came up with number 5, the legal and practice and ethical standards, not the results of the timekeeping data are the appropriate anchors? Reuben Brown, okay? That is not anything that I proposed. That was Reuben Brown who said that, and they were really right on that, as we've seen subsequently. And finally, you need to do both trial and plea cases in your study. I didn't think that would work. We went down to Texas and saw it, and there she is, Dottie Carmichael. She's a brilliant research scientist. If you get the Texas A&M, if you get the Texas report, Dottie and her team have remarkable research credentials. And it was very important that they agreed that the timekeeping can't be the anchor, the standards are the anchor, and also that trial and plea was their idea. And it worked, to the great surprise of Norm and me, who were sitting in the room and watched it work, and we were both very skeptical of it. She's probably, that's probably the best research team that we've had work on this methodology, and their contribution was invaluable. Now, let's talk about the law and standards, okay? Nothing but the old Strickland performance standard, oft criticized. Reasonably effective assistance of counsel pursuant to prevailing professional norms. That, the Supreme Court says, is the proper measure, that's what we're trying to do here, measure of attorney performance, okay? So what professional norms could the Supreme Court have been referring to? Okay, well, let's take a look at that. As we have long recognized that prevailing norms of practice, as reflected in ABA standards, are guides to determining what's reasonable. That's what we're looking for, guides, and we're looking for measures, okay? Although they are only guides and not inexorable commands, these standards may be, here it is, valuable measures of the prevailing professional norms of effective representation, and cites directly to the ABA criminal justice standards, prosecution and defense function. So we said, let's look at those defense function standards, okay? Though the standard for counsel's performance, this is Missouri versus Fry, is not determined solely by reference to the codified standards of practice, these standards can be important guides. How many times can they say it, okay? We finally said, you know, they're onto something. It noted at the time that 94% of state convictions are the result of guilty pleas, and they were relying on DOJ statistics. Okay, we used to have a trial system, we now have a plea system. So, there is a standard, okay? There is a norm, okay? Who developed that norm? Prosecutors, defense lawyers, judges, and academics. They were all in the room where it happened. This is their collective view, okay? So we had them all in the room when the most important question of this study was developed and formulated. It's Criminal Justice Standard 4-6.1b, the duty to explore disposition without trial. That is, plea, okay? What does that standard say? It says in every criminal matter. That's a good start. Not in some, or some that would be, you would think would be important. In every criminal matter, every misdemeanor, okay? To which, you know, you're entitled to counsel. Defense counsel should consider the individual circumstances of the case and of the client, and should not recommend to a client acceptance of a disposition offer, God, mistake on there, sorry, unless until appropriate investigation and study of the matter has been completed. You don't go up and meet your client in court and pleading, okay, having looked at the prosecutor's file. You will complete it. Okay, it's not that you kicked around your study or with your buddies, or kicked around your thoughts in your investigation. You actually have to complete your investigation of the study before you recommend a plea to the client. And we have all of those people who agree on that. Such investigation and study should include discussion with the client. You got to talk to your client, okay? What we try to do is quantify, well, how long should that be in a misdemeanor case, in a high felony case, a low felony case, et cetera. An analysis of relevant law, an analysis of the prosecutor's evidence, an analysis of potential dispositions, and an analysis of the relevant collateral consequences in every case, okay, before you would ever recommend a plea to your client. That changes things, okay, dramatically. Defense counsel should advise against a guilty plea at the first appearance. So it's not surprising that when we took this into the courts, they're a little upset about that. Okay, wait a minute, I got 200 people in my courtroom here, most in orange jumpsuits, most of them are black and brown, and I got to get these people through here. What do you mean you want to talk to your client for 35 minutes? Unless after discussion with the client, a speedy disposition is clearly in the client's best interest. We tell the experts on the Delphi panel, treat that standard as you would treat the most important instruction from a judge in a case you tried to the jury. Okay?
We're 15 minutes in, Steve.
I'm done. I made it. I want to turn it over to Malia now.
All right. Steve, can you stop your screen share?
That's a good idea.
I think I can do it for you.
Go ahead. Good.
All right. I want to just take up where Steve left off and talk a little bit about the component parts of ABA SCLAID workload studies, with the caveat that I kind of jumped into this in the middle of, so after Missouri and Louisiana, and at the kind of tail end of Rhode Island and Colorado. So I have been involved in the entirety of Indiana, and we have 2 pending, one in New Mexico and one in Oregon, that I have been walking us through. Steve mentioned that it's a 2 skill set analysis. It's also a 2-part analysis. There's a system analysis, which Steve likes to call the world of is, and a Delphi analysis, which is the world of should. I want to take those 2 apart and talk a little bit about some of the pieces and what we've kind of learned and changed as we've gone through our now 7 studies. So the system analysis, this is really about public defense as it is in the jurisdiction that we're studying. And it can far and away be the most challenging part of the workload study, especially if you have non-centralized systems. Because if you have a county-based system, you may be pulling from different court management systems to try and gather the data, different PD systems to try and gather the data. In non-unified systems, they sometimes count cases differently, which can be an absolute disaster for trying to understand how many cases they're handling and of what type. And trying to kind of check, for example, public defense data with court data can present many of the same problems. You know, if the court counts a case or a case number as a single case, if it's a multi-defendant case, it's not going to match your PD data necessarily, and that can be incredibly problematic, especially if you're trying to get a picture of the entire public defense system where they're using full-time public defenders and court-appointed counsel to do conflicts for each other, and you're trying to get a picture of the whole system. So there are a couple different ways of trying to get at this world of is and understand how many cases and how much time they're spending. One Steve mentioned was the timekeeping methodology. And that is used in a bunch of studies, as Steve said, best in Missouri, where they actually had been keeping time and they had a statewide system and they were able to kind of say timekeeping is, you know, a condition of getting your check. And they had someone who was willing to do that. We've tried in different jurisdictions to put in place timekeeping for a study, which is often done like a kind of snapshot study that only goes on for a certain length of time. And candidly, it doesn't work very well. If you actually look at the timekeeping, it doesn't get into the right buckets. Often it doesn't get, I mean, introducing timekeeping for the purposes of a study without giving about a 6-month run-up of people getting used to it and getting good at it and getting really uniform in how they do it and what they put in different timekeeping buckets is really challenging. So as a result of that, when the timekeeping didn't go well in Louisiana, they developed a full-time employee methodology, an FTE methodology, which looked at the number of people that they have in the system, and then estimated how much time they were spending based on what a full-time employee would spend on case time. And in places where you can't get a good estimate of that even, you really have to say they're spending all their time on cases, which we all know is not true, right? There's training time, there's meeting time, there's admin time. And that essentially has to be discounted if you use an FTE methodology. So it's a very conservative methodology, but it's one we've had to go to in a number of jurisdictions because the timekeeping piece just was not accurate enough to rely on. In the FTE methodology, one of the things that comes up a lot is if you have court-appointed counsel in the system, or you have contract offenders in the system, trying to estimate what percentage of an FTE they are, if that is not something that already exists in the system where they're required to give an estimate that's based on something, is really problematic. Even in places where they actually are required to give an estimate, when the system has actually done some auditing on it, those estimates have proven kind of dodgy in terms of how many cases they're taking and how well they're reporting the outside work that they're doing. So you have some issues in terms of data that come up on both of these sides. But having this world of is critical, because what you want to be able to do is compare the information that you get from the Delphi, the time estimates that you get from the Delphi, to what they're currently doing in order to come up with what they're deficient and make a recommendation about how many more people they need in the system to handle the cases that they have. And so if you can't figure out the cases that they have or the people that they have to do them, you can't conduct that deficiency analysis effectively. And in recent ones, we've had to put some caveats on that analysis, some very considerable, and just kind of say, here's the data that you would need to collect to be able to do this with more reliability. And that is exactly what we do. When the data is insufficient, we try and point them to the data that the system needs to collect to be more effective at doing its own needs assessment. The Delphi portion of the study is the world of should. And Steve talked a little bit about this, right? You're using the expertise of defense attorneys from the jurisdiction, and you're taking them through a 3-round inquiry into how much time they need in different types of cases to do different tasks, how often those tasks are needed in those different types of cases. And this segmentation is really, really important because as most of you probably know, we are all terrible at estimating how much time we need for a big task. Anyone who's tried to, like, this is a group of largely academics, anyone who's trying to like budget their time for a grant project knows very well that we're kind of terrible at it. And one of the best ways to trick the brain into being better at it is to actually segment the task into smaller and smaller parts and think about how much time you need for those smaller pieces. In the 3 rounds, we do the first 2 online using a survey platform. Steve talked a little bit about that. I'll talk more about it if people are interested. And then we meet in person, and the goal is consensus. The goal at that last meeting is to get about 2/3 of the people to agree with the result about the time needed and the percentage of cases of that particular type in which the event occurs. So like how often you need an expert to consult an expert witness in a sex crime case that is going to trial. And when we get that 2/3, we call that consensus. And that is the kind of time and incident numbers that go into the Delphi result. And I really want to talk a little bit about some of the evolution of these, because the Missouri study doesn't look a lot like the Indiana study and or Oregon and New Mexico. And we want to kind of talk a little bit about how the lessons we've learned and where that's taken us. Probably the single biggest lesson is the number of Delphi panels. So Missouri, Louisiana, there was 1 Delphi panel that was asked about different case types that ranged from misdemeanor all the way up to homicide. In some of those studies, there were appellate case types, and some of them there were juvenile case types, but not every person in that room has the expertise in those case types. So not every person was answering questions for each case type. And at some point, we kind of looked at it in Indiana and said, well, hey, your juvenile lawyers are not taking a lot of appellate cases. There aren't a lot of people in this system that you would say would be expert on both of those. So what happens if we separate out juvenile? And in Indiana, it was the first place that we've done a workload study where the public defenders are the people who take the child neglect cases, which there's a statutory right to counsel in Indiana. So those cases got separated out and were a completely different panel, because not only are the cases very different, and there's not a lot of overlap in the people who take those cases and the people who even take juvenile delinquency cases, but the courts are different, the operations are different. And so you not only have difference of case type, but you have difference of the tasks that you do in a child neglect case don't look like the tasks that you do in an adult criminal case. And separating out the Delphi panels allowed us to really specialize those case type and case tasks. So in Indiana, we actually did 4 Delphi panels, one for adult criminal, one for appeals, one for juvenile delinquency, and one for juvenile dependency. Thankfully, that's the most we've ever done. We're doing 3 in New Mexico, 2 in Oregon. And that has proven, I think, to better reflect how public defense is actually practiced, which is what I think should dictate how many Delphi panels you do. In case type, case task selection, we leave that to a group of lawyers from the jurisdiction. We convene essentially a smaller Delphi panel, a group of about 8 to 10 lawyers who've been practicing for a long time in the area that's going to be covered by the Delphi panel, whether that's adult criminal or juvenile or appeals, and ask them how they group their cases. What is a reasonable way of grouping similar cases together for the purposes of studying them? And then in those cases, what do they do? What are their tasks? How can we come up with a list of 8 to 10 tasks, sometimes 12, that successfully capture how an attorney works on a case? The benefit of that is that it reflects practice in the jurisdiction. The kind of, if there's a downside of that, is that it's not the same. These aren't, the case tasks in Indiana are not the same as the case tasks in New Mexico, or not the same as the case tasks in Oregon. And so there isn't a set list that we can give you and say, execute this. There has to be a selection process for each state, and that's time consuming and very specific. On participant selection, what we have done is to essentially utilize the public defenders and key judges and private lawyers to try and compile a list of everyone that they think should be on the Delphi panel for a particular area. So in adult criminal, who are the defense lawyers that you think have the requisite expertise and level of practice to be involved in this process? And then once we get as big a list as we can, and in that process, trying to get geographic diversity, gender diversity, racial and ethnic diversity to the extent it exists in the bar, which can itself be a challenge. All of those things, we then run that list by kind of a super committee, a group of 3 or 4 like real experts to say, are there people who are on this list who you would say do not have the requisite expertise and adequate level of practice to be on this list and participate in this effort to set standards? Are there people who should be on who are not? And once that gets run, so neither the original list nor the kind of process is run through us. It's jurisdiction specific. And once that list is kind of finalized, that's the list. That again has some benefits and drawbacks, right? As you go through this 3-step process, only the people who participated in the step before can participate in the next step. And so you have this level of attrition that comes down, and you are not in control. The diversity that you start with in the big group, you can push people to try and answer. But if you happen to, despite your best efforts, lose people along the way of a particular group that you'd wish would be in, it's actually really hard to kind of address that, other than to try and encourage people along the way and extend deadlines for them to try and get them back into it. Steve talked a little about the survey interface. I do think this is one of the best areas in which, thankfully, surveying platforms have helped us in the last 10 years. When they initially did this, and you can see this in the Rhode Island report, if you've looked at our reports, they asked each question and had like a checkbox for an answer. And now survey interfaces can look more like Excel spreadsheets, which allow this to be done. I mean, it is a very long survey to start with, even once you've reduced it down to the specialty of adult criminal or juvenile. If you have 8 case tasks and 10, 8 case types and 10 case tasks, then you are asking for, I can do this math, 80 times, so 160 questions, and then you do a plea trial distinction. That's a lot of boxes. That's 320 questions effectively. And to write them all out, as opposed to allowing them to fill out a chart for each case type, is really, really long. And so I think we've been great at reducing attrition by improving the survey interface. They also now really let us do a lot of great work around, like, you need a reminder about what the case type or the case task means, and we can put those definitions in hover boxes. And we've used Qualtrics for the last couple that we've done very successfully. And if anybody separately wants to kind of see that, I can probably arrange a demo and walk you through it. It's actually hard, because it's so interactive now, to put them in the report, even in like an appendix, because you can't condense all that functionality into print, because it's a very interactive survey. And then in between the rounds, we provide data. Sorry, Andy, I'll wrap it up. I saw you come on. Provide data to kind of inform the next round. And one of the things that we do with that is to trim the data to allow for outliers. And that process is really important. It's a decision made by whoever we're using as our kind of surveying and data experts. But they look at the data and try and determine where the outliers are and trim it up. And that helps drive the group toward consensus. I think the trimming piece is an important evolution, and that it's flexible, and that you should look at it at each kind of survey point to determine how much to trim. I will say that traditionally it's been pretty considerable. Like, you trim 20% from the top and bottom to try and kind of push toward consensus and get a range. And then in the final meeting, the in-person meeting, that's really important for discussion, because you have questions about where people put certain kinds of time, or whether people thought about this, or if in the juvenile delinquency, you have a lot of, well, if I'm consulting with or getting an eval, is that an expert, or does that go in just kind of case prep? All of those questions can get answered in the final in-person. I always like to say in that meeting that actually it doesn't really matter where you put it, as long as you only put it in one place and you all agree on it. So that is kind of, that is important. And I will also say that this has probably been the biggest evolution during COVID, because we have now done several of these in-persons online, which takes a considerable greater amount of time than it does to actually go there and sit in a room together. So there's a massive inefficiency. It's worked, we've done it, it's successful, but you could only do a couple of case types at a time, as opposed to like just having an all-day meeting and camping out and getting through it. That does not work when we're talking about online. I really kind of want to allow for questions, so I'm going to just go to that. Sorry, Andy, if I went a little over. And I do think that the evolution is like, that's really what we tried to outline in the report. The purpose of the report was to allow other groups to kind of see what we'd learned and create their own methodologies and adapt them. And as many people out there doing workload studies, the ABA wants no part of a monopoly on this at all. We'd like other people to be out there doing it, because they are very time consuming, and we can't possibly keep doing them forever. So
Thank you, Malia, and thank you, Steve. This was really enriching. I have seen one substantive question in the chat. I would suggest that if other folks have them, if you just want to raise your hand, and we'll be able to unmute you, and so that you can ask your question. But I'll just read out the one that Mike Mrozinski put into the chat box. He says, "Who makes up the super committee that weighs in on Delphi panel participant selection? It seems like there may be some overlap between the panel candidates and the people who are sufficiently knowledgeable that they can evaluate potential participants."
Right. So if you're going to be on the panel, then you are not part of that super committee. It's usually 3 to 5 people. Sometimes there are some retired judges that have done it. Oh, Claire is Scott. Sorry, that was funny to me. Oftentimes, like, we've had people who have been long time serving on the Indigent Defense Board, or just like really, really experienced defense lawyers in the jurisdiction. Steve, you want to add to that?
No, I think that's, we need somebody other than ourselves to be picking these lawyers to participate. And so we got to try and find people who are really highly respected in that jurisdiction. And of course, they serve as validators for us too.
Right. I will say, I'm just like thinking, but like Bob Berukowitz is actually, I saw him raise his hand. That's a perfect example. If I were doing one in Washington State, Bob's far enough away from having practice, but knows everybody, and he would be a great reviewer of the panel, but not necessarily someone that you'd bring into the Delphi panel itself and have as a participant.
Bob, that seems like an appropriate segue to ask you to ask your question.
Thank you, and thank you, Malia. I've asked you guys about this before, but I would like to ask it again. Could you say a little bit more about relating the is to the should? If timekeeping is unreliable and FTE is difficult to determine when you have contractors who are only part-time, why even do that? And when you do it, how does it inform the Delphi panel to have this inaccurate time data?
So it doesn't inform the Delphi panel. The Delphi panel never sees it. Its sole purpose is in the needs assessment part. You don't even, I mean, those two processes are unrelated until the report itself. But at some point, if you want to use this study to help a jurisdiction figure out how many more people it needs, maybe even what kind of specialty people it needs, right? How many lawyers should they be assigning for like sex cases or homicide cases? You know, how many people do they need to train to make sure they can do that level of case? Then you need to be able to understand how many people are in their system and how many of those cases they've historically had, so that you can see the trend lines. And then if you compare that to the Delphi time, you know how many cases they can handle versus how many cases they have. And so that's its purpose. Its purpose is to actually address the needs assessment, not to have any influence on the Delphi panel itself in determining how much time they should be spending.
Okay, so it's used after after you get what should, you can say, okay, this is what we have, and so we need this much more.
Right, they're siloed essentially until the end. Thanks.
One other piece that I'd like to add on your question, Bob, and that is, you're absolutely correct. I mean, I think we have almost half the states right now with full-time statewide systems, and another half that have these, contracts and court-appointed, and lawyers do some of that work, but they have a lot of other work in their practices too. And so this means that when you go to the legislature, it's very difficult to tell the legislature the answer to a very basic question. How many people do you have? And how many cases do you have? And if you're in that jurisdiction, that is going to present a very serious problem to you. And so it's at this point that, the ABA recommendation, I think it's in the 10 principles, is that there's a preference for a statewide system. And the reason, one of the reasons for that is that you can tell a funder, this is how many cases we have, this is what the case types are, and this is how many people we have. Absent the ability to do that, it's very problematic asking a funder to fund you because you can't tell them what you're doing.
Yeah, and I will say one of the things that we do now is to try and identify the data that maybe the system doesn't have that it ought to be collecting and try and help them through that. And this work has led to a lot of conversations around how to get a better FTE estimate on court-appointed counsel or contract counsel. What is the data that you really should be collecting from them, and how you should condition your kind of payment systems in order to get it. And so it's opened up areas that now the ABA is kind of digging in on that I think will be helpful. But that focus has come from seeing these system analysis and what would be helpful and what doesn't exist.
Thank you, Bob. Let's move on to Scott, your question.
Thanks, Andy. So one of the issues that has arisen a few times in regards to the Texas caseload guidelines is we get questions from defender offices asking, one, they want to know, what would be our recommendations regarding a caseload or a number of cases to carry at any particular time, as well as, this distinction between like closed cases versus number of appointments that an attorney gets in any particular year. Our guidelines are based on closed cases on an annual basis. And really, the best response I give to them is, the best I can do is just like divide that annual amount of cases by 12 months and try to keep your lawyers, within that in terms of number of appointments in any particular month. I don't know if y'all have, in any of your other studies that you've done, if you've gone, to the question of how many, cases should a lawyer have at any particular time, or appointments versus, closed cases.
Steve, you want to start or you want me?
No, why don't you start?
So I totally agree, Scott. I actually think this is a huge issue as we because of the pandemic and because of the massive backlogs. So I would say that our studies tend to look at cases opened in a year, right? And they should kind of track with a rate that's closed in a year, but it's just a huge problem now because cases aren't closing. And the idea of an open caseload limit, I actually, from not related to these studies, but I know Bob is working on that in Washington, and we ended up looking into a couple of places where they have them, but they're either not followed. So I think New Hampshire has one, but doesn't follow it, and or they're like very high, and so not particularly helpful. But I don't know, Bob, do you want to step in for 2 minutes and say something about your work on that? Because I'm not sure our workload studies, Scott, I don't think you're wrong. I don't think we have the best answer on that.
I agree. It's a big problem in the pandemic. Our committee, which is the Standards Committee on the Council on Public Defense of the State Bar, is kind of doing a very primitive skeletal version of what you guys have been describing. We're actually developing a written survey that we're going to send to people who are practicing to get a sense of what factors influence their workload, and then conduct in-person or remote interviews on video with at least, we hope, 20 or 30 people to get a sense of what they think the open caseload should be, informed by all the factors, because there's two things we're looking at with regard to our standards. we have a annual new case limit, which is too high, but it's better than some. But it's conditioned on being fully supported, but fully supported is not defined. So this survey that we're doing, which will be both a combination of writing and in-person interviews, is aimed at understanding how we should define fully supported paralegal, social work, and so forth, and how many open cases people can actually have at a time. So those are the two things that we're looking at, and we hope to have answers by sometime, I think, in the spring at the outside.
One of the things I've been doing is talking to a lot of people who do work in the child neglect arena, because those cases go on for years until they're resolved. And so they have done some more work around this, just because it's just kind of a lot of it is maintaining client contact. And so Scott and Bob, I will share what I find, but there's been more thought about it in that community about open caseload limits than there has traditionally been, I think, in more core criminal.
Right. In Washington, we actually have an open limit for dependency cases, which is 80, which everybody thinks is
Too high.
And so there's an effort both by the State Office of Public Defense and by the Office of Civil Legal Services to get that number closer to 60. And those two, there's parallel efforts going on there. And then we're going to look at that once they're done with that.
Yeah, but it doesn't surprise me that that's been where the thinking has come from.
Let me give you an example that may be helpful. We've litigated this question in Louisiana. And of course, we had the great benefit there of having Eric Stilling, who's really a genius on this stuff. And Louisiana was, as you know, has a system of statewide system, and it has also uses part-time lawyers. So that presents that whole FTE problem. And Eric was able to develop a methodology and a data retrieval system that passed muster of the largest accounting firm in Louisiana, Postlewaite and Netterville. And so we could get an FTE estimate. So we walk into court, and let's take an example. We concluded the Delphi panel concluded in Louisiana that for high felonies, that would not include LWOP, for high felonies, approximately 70 hours per high felony on average would be required. So if you had a lawyer who was willing to work 2,100 hours a year, that would mean 30 high felonies, okay? So what we do, but how do you translate that into an individual lawyer, okay? Eric developed an algorithm which we used successfully at trial, where you take the lawyers. We took 3 lawyers. We were just dealing with 3 lawyers in one division of a criminal court. And we took each of those 3 lawyers and we say, here's what he had at the beginning of the year coming in. That's going to roll over. Here's what he's picked up. That we can capture. And we were doing this in June, like through June 30, okay? And we can tell you how many hours he has left, okay? Given what's rolling over, and then you have to assign a depreciation rate for those cases from the prior year, and what he's picking up in this year, and how many hours on average he should be spending on those cases, okay? And here, Judge, is what he's got left, okay? He can't take any more cases, okay, until about September. And then he can only take 1 or 2, okay? And he can't have any more cases, okay? And we have to keep him at this level, okay? And we'll be reporting to you, okay, quarterly, so that you can monitor this. So we have the ability right now to operationalize that number and quantify it. And it's a fairly sophisticated algorithm, but we know how to do it, okay? So particularly in the 25 or so states that have full-time systems, statewide systems, our ability to capture that data and present it at trial is quite good. I think, like any of these methodologies, it'll keep developing, okay? And Eric will keep adding to it, but it's a pretty powerful tool.
So I saw a couple of other hands up. It looks like right now Meg Ledyard has a question.
Yeah, I mean, Steve talked about a lot of what I was sort of thinking about. Is this time, you know, like how long are the cases taking? How much work is, but I assume that it's not, so maybe you could speak to the non-lawyers a little bit more about this. I assume that it's not distributed uniformly across time, right? So like when we talk about cases, we talk about doing investigation very early, and we know that if you're in court, obviously there's a lot of work at the very end, right? And so my question is just, can you just talk a little bit about that so I have a better idea in my head while I'm thinking about these things? Like, what does pushing out everything do in terms of like workload shifts, I guess?
Okay, keep in mind, we're going to talk, you know, I just gave you that example of those 3 lawyers just because it makes a nice story. But ultimately, we have to do this across the system, okay?
Right.
Yeah, and the questions you're asking about, hey, a lot of that works at the end of the case. So when does that go? Well, that's all in the assumptions in the algorithm.
Right, I understand that, but can you talk, I mean, Eric may be able to talk about what those assumptions were, right? So what's the reality of, because as a data person, as a math person, I'll think about a distribution that's uniform across the time of the case, right? That's the easiest model for me to make. And I know that that's not true. So if you can just give me a little bit idea of how you decided on, like, did you use the data from your workload studies to figure out when in a case the majority of the work was happening? Did Eric, did you make that up? Can you tell me anything about sort of how you decided on that distribution of workload across the time of a case? Because that'll help me think about what happens when I expand that timeline from COVID, about how much work is still going to be left after we get out of this mess. And so for our individual attorneys, what does that mean for them?
Yeah, I think COVID presents really difficult problems. But put COVID aside for a moment, because COVID's going to go eventually, and we're going to have to solve this problem. Eric talked to really knowledgeable lawyers about, well, where is this time coming? How can we, and set up a set of assumptions. Now, the best way to test out those assumptions is how public defenders are going to test those assumptions out, everyone, okay, within the next 5 to 10 years, okay? They're going to do timekeeping, okay? And because that's the way that you get reality into the assumptions, and you modify the assumptions as you go, okay? So we're not going to be able to live in this, well, we just can't tell you world anymore. I can assure you that private practice does this all the time, and so do engineers and architects and you know, any professional service organization in the 21st century has a model like this. Different in a lot of ways, but they have a model like this where we've got, this is just a budget, okay? And then we want to track that quarterly against actual. And if the budget is off, okay, if the algorithm might be off, then we're going to adjust the algorithm. And then in 5 to 10 years, you know, we'll know, we'll have a really good algorithm. And we'll have a lot of timekeeping data to test it with in reality.
I agree with all that. Yeah. Our problem is sort of thinking, my problem or what I have to deal with right now is sort of thinking about what that looks like to test. So I'll talk to Eric.
You should. He's a genius. Okay.
Yeah, I know.
I think he's here, Steve.
It's okay. We're at the end of the hour
Yeah,
anyway.
I don't
want
want to, and I don't want to put him
bore
on the
everyone
spot.
else with this. So.
No, and I don't want to put him on the spot, but I would love to be part of that conversation.
Yeah.
If it's something we could set up separately.
Yeah.
I think that would be really, really useful.
Yeah, I mean, we're doing timekeeping in our jurisdiction now. We're doing hourly for our assigned counsel, but the problem is that we started around the same time as COVID. So a lot of our data is just commingled with that.
Keep in mind that although we lost at trial, when the trial judge signed the state's proposed order, including all its typographical errors, verbatim, we won that case in the Court of Appeals, and the Court of Appeals said we were entitled to that remedy based on the data that we had shown. Of course, we lost that case in the Louisiana Supreme Court, but we knew we were going to lose that case there all along. Our plan was to go up to the United States Supreme Court, but as you all know, some not so funny things have happened along the way to that forum.
Appreciate your philosophical approach, Steve, and I would love to keep talking about this, but we do try to respect people's time, keep things for an hour. This has been immensely enriching. Really appreciate you guys actually walking us through the report, because there is quite a lot of quite good experience that you've been able to summarize in there. It's much appreciated. This is a field that, I don't know, in the last 10 years since that Missouri report has seen several really, substantive contributions, large ones from the ABA, large ones from other authors as well. So there's a big picture here, as well as digging down into the methods. There is also this kind of growing consensus around the idea of doing these kinds of studies, and a question about what it means when you have a sort of a critical mass of them at the national in the national picture, for what the implications of that are. And so it's very helpful to have a report like the one that you wrote, which brings together some of this thinking, starts to try to take stock of where we are, and there's obviously many more conversations to be had around that. I hate to cut these conversations off, but I also sort of love it, because when we get to a conversation like this and we're clearly in the middle of it and there's more to be said, I love to leave people wanting more, and I also always have to apologize for it, because it seems so terribly cruel. But I just want to thank Steve, I want to thank Malia, I want to thank all of our other contributors today. And we will be putting this video up on Vimeo within the next couple of weeks. And in the meantime, do stay in touch. We do hold this forum every month, and anybody who has anything else that they want to discuss with this community, please do let us know. Final word to Steve and Malia, and then we'll close it out.
Malia, you go first.
I don't really, I don't have anything. I'm super excited about continuing that discussion. I will say that we're trying to address some of the problems of differences between the different workload studies, not just in the ABA studies, but across studies, looking toward whether there's some national information that could be divided from it. So if you think about the next steps for us, or divined from it, that's where we're heading. So I'll leave you with that, and I would love to come back and talk about it when we're further along. Steve?
Okay. Yeah. First of all, we tried to the best of our abilities to be as intellectually candid as possible in this, and to describe, hey, we got it wrong here, or we got it wrong there, or we changed it here, or that sort of thing, because it was a very new and different direction to take this research. And I hope you read the report, because I think that candor will come through, and you can see the lessons that we learned, and the lessons to be learned that are potentially out there. Secondly, I'm not going to do these workload studies anymore. I'm too damn old, and I'm going to limit my efforts to testifying before Congress and in state legislatures, and testifying at trial. But Malia, I hope, you know, at least I've encouraged her because I think she really brings a lot to this thing, particularly not only on the law, but also on the survey and the technical stuff. I hope she continues to do it, but you won't have me to kick around anymore. I'm going in a little bit different direction now. Thank you. Thank you, Andrew, for having us.
Absolutely. Scott requested the report. I will shoot out the link to the whole list just so everybody has it. And yeah, we'll certainly miss kicking you around, Stephen. And we'll look forward to engaging with Malia. But thanks to everybody.
All right. Very good.
Thank you.